Welcome back, everybody, to the main room and the next plenary session. I'm very pleased we have this opportunity to discuss an exciting book on exponential inequalities, and one of the book's editors, Sandra Fredman, will be leading the discussion. Professor Fredman is professor of the laws of the British Commonwealth and the USA at Oxford. And I don't have time to share her many other impressive accomplishments, but as they say, and I think especially among this crowd, she really needs no introduction. So with that, I'll hand things over to get her started.
Well, thanks so much, Kelley, and thanks to everybody for joining, especially to the panel members. I'm saying hello from Brussels, where I'm at the ETUC conference on a blueprint for equality. And I imagine all of you are all over the world. So that's the exciting thing about Zoom. So we're here to talk about our book on exponential inequalities. And this was prompted by the experience of the pandemic, where in the beginning, you might have thought it was going to be a great leveler. Prime ministers, presidents, everyone could get the same virus. But it very soon became clear, it's probably clear all along, that quite the opposite was the case. What happened during the pandemic was that pre-existing inequalities were amplified and aggravated, and not only along the straight line of increase, but in an exponential way. So we all got used to thinking about the R value of the virus multiplying in an exponential way. So we had the idea of thinking about the crisis from the pandemic as in terms of exponential inequalities. And certainly that happened everywhere, in so many places throughout the world. People who were living in crowded circumstances didn't have space in their houses to keep themselves safe. Many didn't have houses at all, or water or sanitation. Many didn't have access to healthcare or vaccines. Those who were in all parts of the world who were in precarious jobs didn't have access to sick pay. Those at the front line were much more exposed to the virus. And among the many other things, many people, women and others, were exposed to much greater domestic violence by being shut in. So this prompted us to ask the question, where are equality laws? Why has so little use been made of equality laws? Are they not fit for the purpose? And is there anything that could be done to make them better? And so we brought together this really great collection of researchers and practitioners in equality laws from all over the world, who will all appear in our book. And you'll see we have contributions from Colombia, from Brazil, from Kenya, South Africa, India, the US, Australia, the UK, Europe, Hong Kong, Ireland, and others. So it is really a very multinational collection of essays. And I think what's come across is the really quite extraordinary continuity of themes throughout all of these chapters, where everybody can explain, obviously in their own context, how the pandemic amplified and deepened inequalities, and then turn their minds to the role of equality law. And I think I'll just pick up, before we turn to our panel, three themes which seem to have emerged. The one is that clearly the people who are most affected by these inequalities were people in poverty and those who were exposed to socioeconomic disadvantage. But equality laws traditionally have a blind spot about thinking about poverty and socioeconomic disadvantage as a ground, that equality law or anti-discrimination laws are about status, race, gender, disability, whereas economic inequalities are for policymakers. So that's one gap that needs to be traversed. The second is intersectionality, which we've all been very aware of before, that the silos of different grounds make it difficult for us to conceptualize and act on through equality laws, this amplification, synergistic approach. And the third one, which comes across so strongly everywhere, is the individualism of anti-discrimination laws, both in the conceptualization, an individual must prove that they have been discriminated against by another individual, and in the enforcement and application structure, that is the cost and expense, the slowness, the retrospective nature of individual complaints procedures. So many of our authors have thought about how to surmount these. Really at the forefront of them, the authors on our panel. And before I introduce them very briefly, I'll just say one more thing. I'll encourage you to please also listen to our series of podcasts, which are the third set has just been published on the Oxford Human Rights Hub. There are 4 altogether, and it is really a conversation between all our authors, picking up all of the themes of our book, which I will also give a plug for, which will be appearing later in the year. But with that introduction, I'm going to turn to our panel. We have Kelley Loper, who is well known to everyone from the University of Hong Kong, Colm from UCL, Beth and Alysia Blackham, both from the University of Melbourne, and Jule Mulder from the University of Bristol. Unfortunately, Jessica Clark is ill and she couldn't be with us. And Shreya Attry, who's the co-editor of the book and really the inspiration and energy behind it all, she is unfortunately also not able to be with us. So I won't give individual descriptions, but only to say that each of our panel are leading experts in equality law in internationally and in their field. And each of them is going to speak for 8 minutes. And if you do have questions or thoughts in the meanwhile, please do feel free to put them in the chat. And I'll collect them together at the end. But we will also have the opportunity for you to put up your hands and ask your questions, or to put more questions in the chat later on. So, right, so with that introduction, I'm going to turn first to Kelley. Over to you, Kelley.
Thank you very much, Sandy. So my chapter in the book considers the capacity of equality law to remedy inequalities that arise from intersecting crises. And by intersecting crises, I mean more than one crisis that occurs at the same time or in close succession. And these separate crises may have quite distinct features, but their negative effects frequently overlap and tend to reinforce each other. And as we've seen with COVID-19, even a single crisis on its own is enough to exacerbate existing inequalities, as Sandy has just described, or even produce some new forms of marginalization. So it shouldn't be surprising that a combination of more than one is all the more likely to amplify disadvantage. So in exploring this idea of intersecting crises, I focus on the situation in Hong Kong. And that's because over the last few years, Hong Kong has experienced several concurrent crises of various kinds. And one of these, of course, is the pandemic. Like everywhere else, Hong Kong has faced its own struggles with COVID-19. The measures taken to try to control the spread of the virus have, to some extent, been particular to Hong Kong, but the ways that they've disproportionately affected certain groups do look very similar to what we've seen in many other places. The second crisis is a political crisis, which encompasses a persistent democratic deficit and a shrinking space for legal and civil society advocacy. And all of this has taken place against a backdrop of severe socioeconomic inequality, which some of my colleagues actually were sharing their research about in one of the previous parallel workshops. Hong Kong does have one of the largest wealth gaps in the world and an acute shortage of affordable housing. And this could actually be characterized as an additional crisis in its own right, except I would argue it's essentially become normalized over the last few decades. It's probably also not surprising that those most affected by the inequalities arising from intersecting crises have been those who previously lacked political and social voice. And while the political crisis has reduced opportunities for participation for everybody generally, it's made it even more difficult for already marginalized communities to shape or to access the tools that they need to try to remedy discrimination. So for example, migrant domestic workers in Hong Kong have been entirely barred from attaining permanent residency status, and they're therefore unable to enjoy participation rights associated with that status. And this is regardless of the amount of time they've lived and worked in Hong Kong, and this contrasts with other foreign nationals living in Hong Kong who can apply after 7 years. This exclusion has contributed to more adverse outcomes for this group during the pandemic. And in the last couple of years, policymakers have singled out migrant domestic workers when imposing pandemic control measures. So for example, last year, the government tried to mandate vaccinations and weekly COVID tests only for this category of workers. And very recently, it decided not to provide pandemic relief consumption vouchers specifically to migrant domestic workers, even though these had been extended to other non-permanent residents. And it's probably no coincidence also that migrant domestic workers are almost entirely women from certain national origins and doing certain types of care work. And like single crises, multiple crises have predominantly impacted groups, as Sandy mentioned, who are suffering disadvantage on intersectional grounds. So the question is whether Hong Kong equality law is equipped to address these problems. And the short answer is no. It generally does not have the capacity to prevent or remedy such complex disadvantage, or even simple disadvantage for that matter. In fact, the law's shortcomings have restricted their potential to achieve transformation, even in so-called normal times. And these laws include 4 separate statutes prohibiting discrimination on the grounds of sex, disability, family status, and race. And so far, legislators have actively resisted calls to extend these protections to other grounds, such as sexual orientation, gender identity, or age. And although indirect as well as direct discrimination is prohibited, the definition of indirect discrimination was modeled on a very narrow provision in older UK legislation from the 1970s, which makes it difficult for plaintiffs to establish a claim. But lawmakers have rejected proposals to adopt more recent comparative developments that have strengthened discrimination laws in the UK and in other jurisdictions. The Hong Kong statutes also contain very broad exceptions, which inhibit their ability to redress the types of intersectional discrimination experienced by migrant workers and other immigrant groups. For example, the race discrimination ordinance does not allow claims based on nationality or citizenship, even when such a distinction has a disproportionate indirect impact on a racial or an ethnic group. Hong Kong also has broad constitutional equality guarantees, which replicate provisions in the International Covenant on Civil and Political Rights. And while there have been some very important constitutional cases which suggest the development of a nascent substantive equality doctrine, I argue that these constitutional tools have been underutilized or inconsistently applied. So for example, the courts have largely overlooked the possibility of any intersectional discrimination. They haven't even really considered that possibility in cases challenging some of the policies excluding migrant domestic workers, which I mentioned. And this is despite the demographic profile of this particular group. So in sum, the exponential inequalities arising from intersecting crises require much more robust responses than Hong Kong equality law has been able to deliver. And to better understand the relationship between a political crisis, such as a democratic deficit, and inequality, Sandra Fredman's famous multidimensional model of substantive equality is particularly helpful. And actually, our keynote speaker, Jane Okatari, yesterday did a great job of explaining this model also. One of the critical dimensions, of course, requires enhancing voice and participation. But this can't be achieved in isolation. So participation contributes to, and it also depends on, the realization of the other dimensions of substantive equality, including redressing disadvantage, addressing stigma and violence, accommodating difference, and achieving structural change. And by the way, Sandy, my students will have memorized all of the 4 dimensions. So a crisis that diminishes voice, especially the voices of the already marginalized, is likely to reduce possibilities for achieving equality in this more holistic sense. And it's a vicious cycle. Available avenues for influence shrink, discrimination worsens, and the prospects for transformation recede further. So I'll stop there. Thank you very much.
Well, thanks so much, Kelley. And so from the intersecting crises of Hong Kong and the clear deficits in Hong Kong legislative framework, we turn to Colm or Kneed, I think maybe for a slightly more optimistic view, but over to you.
Relatively optimistic is maybe the best way of putting it. Hi, everyone. It's lovely to see lots of familiar faces and names, and to be able to talk about the chapter I've contributed to this fabulous edited volume that Shreya and Sandy have put together. What I want to focus on in the time available to me is to look at where equality law stands now as a mode of sort of rights-orientated legal regulation, and how it is capable, and how and whether it is capable of responding to the challenges that increasingly face it in across the globe. The chapter is primarily focused on European equality law, but I like to think that my analysis has wider application. The chapter begins by taking stock of the achievements of equality law over the last 50 years or so, which I think are quite considerable. Obviously, the situation varies from jurisdiction to jurisdiction, but I think it's possible to identify certain things that equality law has come to do well. Where properly enacted and adequately enforced, significant qualifiers there. It provides comprehensive protection against certain specific forms of discrimination. It has proved to be a sort of flexible regulatory framework. It's interesting that the basic concepts of anti-discrimination law, as developed in the 60s and 70s, have actually retained much of their force and effectiveness 50 years later, despite huge changes in society across the world. And they've often been very effective at establishing at becoming embedded within national legal systems, in the sense of once they're in, they tend to put down roots in national legal systems and be quite difficult to destabilize. I make that point against the context of, for example, here in the UK, a systematic attempt to downgrade human rights protection more generally. The UK government produced its long-awaited Bill of Rights Bill, I should say, yesterday, which, to summarize, basically, in a rather elaborate fashion, tries to deprive an assortment of unpopular minorities of their rights. I'm summarizing, but that's pretty much what it's all about. But it is interesting to me that anti-discrimination legislation tends not to attract the same level of head-on political attacks as other aspects of sort of rights-orientated legal frameworks. And that's been the case across much of the EU, despite the backlash against transnational regulation that's happened there in the last decade or so. So there are very real achievements that can be chalked up to the credit of equality law. There are also, of course, very significant limitations, which have already been flagged up by Kelley and by Sandy. Now, you'll all be familiar with these limitations. I'm not going to spend a huge amount of time going through them. It has limited scope and is very much focused on a certain specific type of central case, as Shreya Ashry has put it, of discrimination. It doesn't cope well with types of discrimination, including intersectional discrimination, that fall outside those central cases. And enforceability can be a huge problem. And the ambition and stretch of equality law is often quite contested. Courts are very, very reluctant to stretch equality law into controversial areas of disputed law and politics. All of these limitations, I think, have been rather graphically highlighted by Me Too, Black Lives Matter, and by COVID. Sometimes these limitations aren't a problem of law. Sometimes they're a problem of enforceability of existing legal standards, but nevertheless, the problems remain real. In fact, I think we're at an interesting juncture when it comes to the application of equality law, where we have very narrow, very strong protection against specific forms of inequality, which then almost falls away completely once you move beyond those areas of central focus. So you see it, for example, again, just using the UK as an example, when it comes to an issue like immigration control, where as long as you avoid the trap of falling foul of the prohibition on race discrimination, including indirect discrimination controls, you can enact quite sweeping anti-immigration control measures, as long as you avoid being caught within the web of equality law. So that's, I think, a very good example of the sort of narrow focus, strong protection equality law applies in certain contexts, but its inability to deal with wider structural problems of inequality in society more generally. Now, what do we do about this? Well, to start with, academic writing, including the work of Sandy already referred to, has already sketched out a very convincing path as to what we do with this. We move towards a substantive equality model, we move towards a multidimensional picture of equality, we extend to include intersectionality, we give wider remedies, and so on. And the problem with all of this, that there's no problem with it as a mode of, as a sort of well mapped out way forward. The problem is that governments and states are persistently reluctant to adopt that model, and that model has been on the table for 20 years plus, and Sandy and Bob Heppel and others developed it in detail. Governments have shown a repeated reluctance to go too far down that route. And you know, we all know the reasons why for that. So we're in danger of coming to something of an impasse when it comes to equality law, that its strength of protection ends up being circumscribed, ends up being bounded. And what I want to suggest is, for those of us invested in trying to stretch equality law, to make it more capable of dealing with the growing patterns of inequality that disfigure our societies, we need, I think, to think in creative ways about extending the reach of equality law. How might we develop new institutional structures that sort of circumvent some of these problems of equality law? Do we need so strictly to insist on the rigor of equality law? Are there times when we may want to deal with problems through different dispute resolution mechanisms? Are we invested too much in command and control legal regulation? Should we be looking for more alternative dispute resolution mechanisms, resurrecting some of the experiments from the 1960s in the UK and elsewhere that looked like institutions like local race relations boards composed of representatives of different communities coming together and trying to have some sort of, oh, sorry, that's my countdown timer, having some sort of dispute resolution mechanism devised at local level? Should we be looking at ombudsman structures? Should we be looking to enhance parliamentary arrangements? all of these questions, I think, need to be looked at again, because we need to, in recognizing the strength of the equality law, which many of us are very much invested in, we need to also recognize its limitations and to think ways of stretching its scope and stretching its impact of the underlying principles beyond the silos in which they tend to be very much bound up in at present. My chapter goes into this in further detail. Read it if you have the chance, but certainly have a look at the edited collection in general. Thank you very much.
Thank you so much, Colm. So that is, in a way, we know the goals. It's the pathway to those goals, which is still very fraught. And so with that, I'll turn to Beth Gaze from Australia, which I think had a somewhat different experience of the pandemic, but still some really striking continuities as far as inequality and equality laws are concerned. So over to you, Beth.
Thank you, Sandy. And I have to say, listening to this, all I've heard so far is that a lot of what happened in Australia is very similar to this. I've actually got a few slides just to guide me through, so I'll just pop them up. Can you see the slides now? Sorry, I'm not.
Yes, we can.
You can. Okay, great, thanks. Because what seems to happen is, for some reason, my my screen just vanishes when I do this. However, so what I wanted to do was to begin to. Sorry, I have. Where am I? Oh, that's where I need to be. Okay. So this is really talking about specifically in the Australian context, but a lot of the comments will be very similar. And what I want to talk about is just in Australia, we had the impact of the pandemic, and then we had further impacts from the government responses to the pandemics. And in a way, the second thing really built on the first to compound that inequality. And of course, you know, we had a very neoliberal government, which thank heavens we've just got rid of. So we are in a more optimistic time at the moment, but we certainly have had, you know, 10 years of really no particular expectations of advance in this area. So it'd be interesting to see what we can come up with now. So the second thing I want to talk about is the relevance and the limits of equality law, specifically in the pandemic context, in the public health context. The need for reform to firstly fill gaps in anti-discrimination law, but I argue that we need to not just stretch it, but we need to actually also go beyond it, to think of other ways of actually assisting people who've got that vulnerability. And it does occur to me that this is not a very practical idea. So it's not something that I think is going to get, even with a progressive government, I don't think we're going to get this adopted. But I think we need to start thinking about different ways of moving in this area, and then future directions in Australia. So the Australian governmental context is very complex because of federalism. So we're dealing with 8 different jurisdictions. We have 7 state and territory jurisdictions. We have the federal jurisdiction. There's a lot of, there's different powers at each level. And the federal government, we have what's called vertical fiscal imbalance, which means the federal government has all the money and very few responsibilities for expenditure. The states have a lot of responsibilities to fund health and education and things like that, but very limited taxation opportunities. So once we have, we have a lot of this to and fro between governments saying, well, no, you pay for that, no, you pay for that, it's not our responsibility. And that happened to a large extent during the pandemic. All our governments since the 1980s have had a neoliberal orientation. So they've all had this idea that market primacy is what should operate. Government should be small, even though they don't actually end up with a small government. But they're very keen on outsourcing and privatisation. So that's happened in our health system as well as in education and so on. And of course, the background to that is it moves good public sector jobs into precarious private sector employment. One of the things our government did do, and this is more at the state level where they were responsible for health than at the federal level, was that they did listen to public health advice and they followed the public health advice. So in some ways in 2020, before vaccines were available, they did a very good job of safeguarding their own population. So it was largely the state governments that acted on this, but the public health advice didn't really think about the discriminatory effects of the directions that were being taken. And health actions are an exception to anti-discrimination laws. So we have this silo effect again, where we've got public health over here, we've got discrimination and equality law over here, and they just didn't interact. And of course, the most affected were the people who are already disadvantaged. So in particular, in that first year, the COVID got into aged care homes in Australia through the very precarious workers who work in the aged care homes, and that's where most of the deaths were in that first year. And that was because of government failures to ensure adequate protection in the aged care homes, so adequate PPE and staff who weren't working between lots of different centres and so on. The other people affected, of course, low-paid workers, the essential workers who had to go out to work, lots of temporary migrants who were just left without any support. For example, international students were provided with no social welfare support. A lot could not afford to fly home. Their work dried up because all of the casual work dried up when people had to stay at home. And so a lot of them were dependent on, for example, the universities and charities to provide food and so on. So what was the government response? So largely what the government did was close the borders. So this was quite a xenophobic response, I guess, isn't it? It was let's keep out this dangerous infection and all the people who might potentially bring it in. And then that spread so that we had internal lockdowns as well. So we had states locking out every other state. So Western Australia, for example, I think only lifted its lockout, Alysia will know, quite recently. But other than that, Western Australians who live in the East Coast have not been able to go home for a substantial amount of time. So everybody had to work. So we had lockdowns, we had public health measures, masks and ventilation and so on. And the government provided financial support. So everybody who could work from home was relatively safe. But of course, the essential workers were the ones who had to go out and work in health, in education, in schools, in the food system and so on. So they were the ones who couldn't avoid being exposed to the risk of infection, because if they didn't have any backup, they needed to be out there working in order to earn the money. And of course, women were put at greater risk in a home if there was any family violence occurring, because it was much more difficult to escape during the lockdowns. And of course, when schools closed, women were expected to provide childcare and to teach children and so on at the expense of their own careers. So the greatest impact, as I've said, was on the least advantaged. So it reflected and exacerbated existing disadvantages. The government financial support was uneven. So there were some really good stories in there. The government applied a supplement to all the social welfare benefits because it didn't want people who were doing casual work to be going out and working because they didn't have enough money. So people who'd been on welfare benefits were allowed to earn a certain amount over their benefit. And the government pretty well replaced that. And what that meant was, while that was paid, families that were dependent on social welfare pretty well eliminated child poverty in Australia. So it reduced from some huge percentage substantially down, but then the government withdrew that as soon as it possibly could. So it was about March 2021, the government said, okay, that's all over. We don't have to do that anymore. And they went back to the existing below poverty levels. The supports to business were amended several times to make sure that public universities couldn't access them. So it was like there was really that sort of, we're picking favourites. Now, turning to the law, what's the limits of equality and discrimination laws? So I've already said the discrimination laws don't really interact well with health or public health laws. So I think there's reform needed on both sides there. So currently the way health is treated in discrimination law is it's only a service. It's dealt with in provision of goods and services. And so there's nothing there that recognises the distinctive nature of health as a human right and as something of great importance to everybody. And the public health laws, as I've said, don't recognise the risk of discrimination adequately. So we had a couple of examples that I talk about in the chapter, which, for example, one of the high-rise public housing towers in Melbourne was locked down basically without notice, so that people could not go out and buy food or get medicines or anything like that because infection had started to spread in that tower. Now, that would never have been done and was not done in any better off areas, but it was done to the high-rise tower, and it's a measure of the inability to think about race issues and so on in public health laws. And of course, the limits of discrimination laws, they don't deal with socioeconomic status. They're focused on identity, not on generalised disadvantage. So just to wind this up, I think there's two directions for moving in the future. So one is that we do need to improve the anti-discrimination laws. They need to recognise the importance of health, and that needs to be probably an area that's identified like all of the other important areas of public activity that we talk about, so that we ensure that discrimination in health services is actually specifically dealt with. It would be good, I'm not sure how they can deal with socioeconomic disadvantage, but certainly Australia's laws need to be more proactive and more oriented towards prevention. And I guess there's some chance we might see that now. I think we also need to campaign for public health laws to be more aware of discrimination issues, so that a law that's purporting to protect people's health should really be also taking account of the health impacts of discrimination. So we can't just have one and disregard the other. But I argue as well that beyond anti-discrimination laws, there's a need for a broader law to protect the vulnerable. And I am a strong believer, I'm a strong supporter of Martha Feynman's vulnerability theory, because it provides a mechanism by which one can say we're not just protecting specific identities or specific groups of individuals who may not have an awful lot of community sympathy. Instead, it flips the idea around to say, look, everybody across their whole life course has the same sorts of vulnerabilities. Any of us could be hit by a bus and become paraplegic tomorrow. So we need to have a system that makes sure that people who are in this vulnerable position are cared for by society. And so it's a way of trying to bring home to every individual that this is actually a social insurance for everyone. Now, I think that's sort of, it's pie in the sky, but I think it's an avenue for starting to try and change the discourse in this area, to try and make it more universally appealing, rather than for people to just see it as something that's for other people rather than for them. And I'll stop there. Thanks very much.
Thank you so much, Beth. I think one of the things that's striking from what you said is that when the government does decide to intervene, you can eradicate things like child poverty just like that. And we also found in the UK, homelessness suddenly disappeared. People with accommodation was found. But picking up your theme of vulnerability, we in the collected essays, we looked both nationally at different countries, but we also picked up some cross-cutting themes, one of which is age discrimination, which was obviously so central to so much that happened. And this is Alysia Blackman's contribution, taking a much more of a life course view of discrimination. So over to you, Alysia. We look forward to hearing your contribution.
Thanks so much, Sandy. And it's an absolute pleasure and a privilege to be part of this panel and also part of this really impressive collection. I'm also going to share my screen in part because I have some pictures that have been done of this project by a very talented graphic recorder, and so her details are there. And I also acknowledge that I am coming to you from the lands of the Wurundjeri people of the Kulin Nation, and I pay my respects to elders past and present. And finally, I acknowledge that this work was funded by the Australian Research Council. So I think that covers all the bases there. In this project, I'm considering the way in which age and its associated time, the corollary of time, the way in which they might amplify inequality over time, and the way in which age and time might interplay with a period of crisis. So to kind of set up this argument, I argue that age and time actually become exponential amplifiers of inequality in and of themselves. So if we're talking about exponential inequality, we need to think about age and we need to think about time. So the first way in which I argue this is I say that actually age serves to amplify other forms of inequality. So our age, and in particular those of us who are younger or older, we might find that our age actually exacerbates other forms of disadvantage. So our age might make us vulnerable to particular types of wrong. And that ties in with vulnerability theory, which Beth has flagged. But we see it, for example, in the concept of gendered ageism, which has been very well written about in the literature, that women are more exposed to ageism than men, for example. But the second point that I put forward is that actually, not only does age interact with other grounds, but actually inequalities compound over time. And so inequality doesn't just increase over our lives, but it actually increases exponentially. So if we experience inequality, if we experience discrimination in work, we then become more exposed to discrimination in our later jobs as our work histories become more unstable or checkered due to that experience of discrimination. That then is compounded by this third factor, which is that our experiences of discrimination have negative impacts potentially on our health, on our well-being, and on our life satisfaction. And that then also exposes us to other forms of vulnerability. So the way in which age and time is interacting with inequality is really complex. It has to be considered in a really nuanced way, but we cannot consider instances of discrimination as simply one-off events. They actually have ripple effects throughout our lives. So in this chapter, I use the idea of a life course approach to try to untangle these complex issues. So the idea of the life course, developed in the social sciences, sees aging and human development as involving age-graded patterns. So the standard typified age life course of study, work, retirement. So we tripartition our lives into those three phases. So for life course scholars, they see our lives as being embedded in these social institutions, in our history, in our context, and in our place, but also recognizing that we have agency to navigate these things so we can make choices as we engage with them. Of course, that tripartitioned life course has never well reflected the situation for women or those who do not feel that kind of stereotype of the normative worker. So that stereotypical life course is increasingly being challenged and breaking down. And we also need to consider that when we think about age and time. But the things or lessons that I think we can take from that, and the lessons for discrimination law in particular, is that we need to see that age and aging is a profoundly social and embedded process. It is embedded in social institutions, and our social institutions set and enforce certain normative standards for how we will behave at particular times. But beyond this, we need to recognize that aging is a lifelong process. We all have an age, we are all aging. Every minute that you spend listening to me is a minute in which you are aging. So this is a continuous process. I apologize. That is a continuous process, and it's not something that we can divorce ourselves from. And so this really brings our attention to the fact that age inequality is something that can manifest across all different ages. And so we should not consider one particular age cohort as being profoundly affected by age discrimination. The other point to take from a life course approach, though, is that our lives are fundamentally linked and interdependent. And this is coming back to Sandy's point earlier about the individualization of discrimination law. The way that we age and the way that we live our lives is fundamentally linked. It is not an individual thing to live as a human. But not only this, when we experience discrimination, it's going to have ripple effects beyond us as individuals. It will ripple out to our family, to our friends, to our communities, to those in the workplace around us. And we need to consider those ripple effects as we think about how we live our lives. Another important point from a life course approach, though, is that discrimination at certain critical points of our lives is potentially going to be more significant or more important. And that could particularly be through times of crisis, but also importantly, from an age perspective, at certain life transitions. And this is why we see discrimination so frequently in recruitment, in termination or dismissal or retirement. So the transition from education to work, work to retirement, these are really critical life points where we might be overexposed to discrimination. And then the final point here is that discrimination has these repercussions or these reverberations across time and across different contexts. Just because we experience discrimination in the workplace doesn't mean it's only the workplace that is affected. And so in studies that I've done with a demographer, Jeremy Temple, we found that actually people experience discrimination across a whole array of different contexts. It's not just work, but it's also in health, it's in education, it's in interactions with the justice system. All of these things work together to inform our understanding of who we are and how we live our lives. And we can't divorce one context from another. But also discrimination accumulates over time and the harm accumulates over time. So as we've said, discrimination law doesn't necessarily deal with this particularly well. We focus on discrete instances of discrimination. We need to prove them. We ask for individual complaints. We have a remedy for one particular point in time and focusing on one context, like work. But actually, if we think about discrimination from this life course perspective, we need to think about how it occurs across time, across contexts, the way in which discrimination might be communal or collective, or have these implications that move beyond just the individual. But also the impacts of discrimination accumulate over time, and the impacts can be long-lasting. And we know this when we look at how people are impacted by experiencing discrimination. A simple monetary remedy doesn't reflect the deep-seated hurt and harm that can occur. But also, we need to recognise that these things are amplified by a crisis. So we need to really engage with the temporal, communal, and the cumulative effects of discrimination when we think about how we advance discrimination law to respond to these impacts. I promised there were pictures. So these pictures just illustrate how we can think about a life course approach and start to think about the way in which this might recast discrimination law. So if we think about life course equality, we need to think about these issues as being overlapping, occurring over time, but we also need to tailor our interventions to critical points where inequality might emerge. So we need to target interventions across the life course, across all ages. And in doing that, I argue that government has a really critical role to play here, because government actually has a role to play at all of these points in our life course, particularly governments who are involved in provision of education and training, including higher education, in providing work as an employer through the public service, and going on through provision of retirement benefits, healthcare, and so on and so forth. So government can actually play a really active role here in considering how inequality manifests over time. And I use the example of gendered ageism to look at how the gender pay gap then accumulates over time to become the gender pension gap, which is so much more significant than what the gender pay gap looks at from a year-to-year basis. But also we need to recraft discrimination law to consider these communal impacts and to consider how these ripple effects might manifest. To address this, I, again, building on Sandy's work, argue that we need nearly a new form, a new generation of positive duties. And I use the example of a new positive duty in Victoria under the Gender Equality Act, and consider how it might actually demand progress towards equality, building on what's been done in the UK, and integrate consultation as a really important way of building communal voice and collective presence to recognise that discrimination is not just about us as individuals. And I'll leave it there because I'm out of time.
Thank you so much, Alysia. Thanks for the pictures too, which certainly help a lot. And the Alicia's chapter also says more about that proactive duty, which is a really interesting innovation, which I would commend you all to carry on reading. So as well as all of these difficulties, the lockdown led to a lot of people working from home, and working from home is challenging in lots of ways for anti-discrimination law. And that's what Jule's chapter in the book begins with, in order to tease out indirect discrimination and its role. So over to you then, and look forward to hearing your contributions.
Yeah, thank you very much. Yeah, as Sandy said, I'm looking at the specific case of remote working, or which is part of the sort of flexible working requirements in the light of EU non-discrimination law, specifically indirect sex discrimination law. And now this is linked to obviously COVID, as Sandy mentioned it. Now we are during a time of lockdowns and work at home orders. just remote working from home is a lot more common, and we certainly, a lot of us have a lot of experience with it. Of course, not the essential workers, but a lot of other people. And in a way, this has maybe normalized remote working. And certainly there's quite a lot of suggestion that it's quite difficult to get people back into the office. And there's also the suggestion that some employers may advertise a lot more working from home jobs, and because they want to reduce their office space and all the costs associated with that. Now, on the one hand, you could say that that is a very positive development. Of course, under the EU Work-Life Balance Directive, sort of flexible remote working arrangements are really seen as a tool to enhance substantive equality, because it potentially can enable carers to care and work at the same time, to arrange their work obligations around their care obligations. And of course, the most prime cases is an area where this may be key is an issue of childcare. So if you work from home and you have a flexible work arrangement where it's not defined when you have to work during the day, you might be able to pick up your children from school or and then work in the evening instead. You might be able to work from home while your children are in a different room once they're a little bit older. Similar things, of course, apply to other care obligations or needs for family members or other people in need. So in a way, this is quite positive, isn't it? If it becomes more normalized, the stigma will maybe go away over time, and it will enable workers to reconcile these different private and professional responsibilities. There's also, of course, a trend that simply because we were all working from home, it simply became more normal that private life disrupts our working life temporarily. So, I mean, the prime example I always think is the one when now all of a sudden saw lots of children on TVs, whilst people were giving their expert opinion on some issues. They were running in and out. There were, I don't know, whether people having children on their arm while explaining what the weather is going to be. So it all became a bit more messy in a way that it might help people with care responsibilities, because that messiness before has often been associated with being distracted, being unprofessional, and a lot of this was tolerated during the pandemic a lot more. And if we can keep some of these things, then that is probably a good development for people who use these flexible remote working arrangements to also take care of children or other people in need. Now, and of course, most of the people who do that are women. So this is, of course, something that then will help women stay in the employment market, and ideally even in full-time positions, which then will have obviously influence on their income and then also on their pensions later on. Now, however, I think there's a flexibility isn't all that positive all around in every circumstance, right? I mean, in the past, flexibility as a working requirement has really been identified as something that disadvantages women, because as long as it was demanded from the employees by the employer. Now, obviously, if you have to be flexible in the way that you have to be available any time of the day to complete work, then people with other responsibilities outside work will be unable to do that. And the flexibility is also not as easy to accommodate within a private home if it's not just flexibility, if it's only flexibility regarding where to work and not so much flexibility regarding when to work. And indeed, if you have an area where home working has been very common for many years, a sort of telework with sort of where you answer phone calls on, then you have to work certain shifts, and you have to do that at home, and you have to make sure that that private life happening around you does not interfere with your work, and as such, that is obviously can then interfere with private life in the family and can create all kind of difficulties. There's, of course, also the question of whether a workplace at home is actually a safe workplace. And of course, as mentioned before, the whole pandemic measurements very much assumed that people will be safe at home, and that is not true for everybody. And again, the issue of domestic violence, of course, has a particular impact on women who are at home. So I think there's a bit of a mixed picture of whether flexible remote working arrangements are a good thing or not, and they obviously very much depend on how they are organized in detail. And so in my paper then looks at how non-EU non-discrimination law, or how maybe especially indirect sex discrimination law, can address disadvantages that may arise from these flexible remote working arrangements. And I think it's uncontroversial that EU non-discrimination law applies to them, because EU law applies to working conditions. And the directive now makes very clear that that includes pay. Also, of course, there is also the equal pay provision in the treaties. Now, and I want to pick at three specific issues that may create some difficulties, and make sure whether to determine whether EU non-discrimination law and indirect sex discrimination can really help addressing potential disadvantages within the remote working arrangements. And the first one is that of comparability of work. Now, comparability with EU indirect sex discrimination is obviously not, it's a bit of a contentious issue, because of course, if we compare, because always the question is comparing based on what criteria. So for example, you could say that part and full-time workers are not comparable because they have different kind of contracts. But of course, within the context of indirect sex discrimination, that difference didn't mean that they were not comparable. Now, here, when I talk about comparability, I first have a question of what do you compare? Is it a question that I'm comparing the different people working in remote working arrangements? Or am I comparing people working in remote working arrangements and people working in the office? And regarding the latter, depending on how these arrangements, or how different these arrangements are, we may come to the conclusion that they're not in all ways, in every situation, always comparable. Because here, regarding equal issues of equal pay and equal work or work of equal value, the court has said that you need to not just form arbitrary groups, but you need to identify groups that encompass all the works who taking account of all the set of factors, such as the nature of work, the training requirements, and the work condition can be considered to be in a comparable situation. Now, of course, in many cases, working from home or working in the office will be the same thing if it's about the outputs that are made. So if I can write an article at home or write an article in the office, makes no difference to my employer, and that should be comparable. But there might be areas where it does make a huge difference for the employer, whether you work from home, and you might be unable to do certain things while you're at home, and so you may not have the same kind of responsibilities. And that, of course, then has could potentially mean that they're not comparable. And then we can only focus on the people who do indeed work remotely. Now, ideally, you would then think that if there's now remote working became so common, and this is not just women who work at home because they take care of their children, but also men, you could still make a case of indirect sex discrimination if you can indeed demonstrate that it's more difficult for women to work remotely than for men. We know that during the pandemic, a lot of fathers also worked at home, but most of the additional childcare was done by the mothers. So the disadvantage from working from home was not the same for men as a group compared to women. Now, but then, is this indeed true that it's more difficult for women? I'm sorry, there are alarms behind me. If it's indeed true that it is more difficult for women to work from home because of all additional childcare responsibilities, and maybe the fact that it is indeed sometimes distracting to work at home if you have children in the next room who knock on your door every 10 minutes because they need something, then I do wonder whether these kind of disadvantages can actually be recognized under EU law, because these disadvantages don't seem to stem from the professional sphere, they seem to stem from the private sphere. And the Court of Justice has indeed made very strict separations. That my second point, where there's an issue here with EU non-discrimination, the Court of Justice has separated private and public sphere quite strictly. And I do wonder how much the court is willing to recognize how equal work arrangements disadvantage some groups more simply because of their private arrangements. Because you could say, well, this is simply not the responsibility of the employer. There have been cases in the past where the court has made very strict distinction between private arrangements and public duties. So they made a distinction between absence from work to military services and absences to work from because of parental leave. They have also, in the context of part-time work, not recognized the different situation part-time workers are in compared to full-time workers when it comes to overtime. So the Halmik case law has been very clear that the court is not willing to consider what it means for a part-time worker to work overtime, and that the overtime 17th hour for a part-time worker as an overtime hour is not the same to a normal regular working hour for a full-time worker, because obviously the reason they are working part-time is often because they have all these other responsibilities outside of the work. But these issues were not considered in any way by the court because it simply didn't consider them relevant for the comparison, because it falls within the area of private life. So now that is not to say.
I'm sorry to interrupt, but we want to leave time for questions. So
yes,
if you
yes,
could wrap up.
right. Yes, I'll wrap up. So the last thing, and I just mentioned this, I think is what is also then an issue, is the question of whether then reasonable accommodation duties that are sort of within the scope of indirect sex discrimination may be possible in some degree, can help employees that they requires employer to indeed recognize a different environment in which remote working takes place at home and the structural context where this is happening, and may have different effects on different people working from home. Right, thank you very much.
Thank you. Thank you very much, Jule. And clearly the question of working from home is going to continue on in the future. So this is very much of a live issue for all of us. Okay, so we now have about 13 minutes for questions.